Hi, this is Kevin Quinley, aka the Claims Coach, broadcasting from the worldwide headquarters of Quinley Risk Associates. I thought I would take a few minutes to try a video message on one aspect of claims management and avoiding bad faith. That is during the trial phase. And specifically, I wanted to talk about situations where you've got a bad outcome, a bad jury award, a runaway verdict, whatever. And there's an allegation later, maybe from the policyholder or from somebody else, that a defense counsel's conduct contributed to the outcome. And there are post-trial allegations of bad faith that involve your selection of a defense attorney who allegedly botched the handling of the case in some way. A couple of thoughts and tips here. Number one, to me as a claims person, and this is not legal advice, I'm not an attorney, do not play one on TV, this sounds like an attorney E&O problem and an issue to me. I don't understand why this is the adjuster's problem. If the attorney in his or her professional activities mishandled a claim, that's why attorneys and law firms have professional liability, professional E&O coverage. So that would be a claim against the attorney. The attorney is typically not an employee of the adjuster. We'll come back to that in a minute with regard to in-house counsel. They're vendors, they're independent contractors expected to exercise their own independent professional judgment. If they didn't do that, and not doing that caused a bad outcome, that's an attorney E&O problem. Now, the caveat here is that unless the adjuster knew or should have known that the attorney lacked skill and competence, that can be a mitigating factor. And so you want to make sure before you go into trial that this highlights the importance of doing due diligence and vetting defense counsel. It doesn't mean that you have to reinvent the wheel. It means that somebody from the claims department had better be prepared to explain the procedures that they went through in putting that attorney on an approved panel and selecting counsel, ideally because of their subject matter expertise, their references, their representation of clients before, their trial experience, recommendations of other clients. You hope that the decision was not largely driven by hourly rate. That's where some problems can come in. Now, it doesn't mean that the adjuster has to repeat all of these steps, but I think it does help if the adjuster is aware of, or if somebody in claims management can testify to the hopefully thorough due diligence process that was followed in vetting an attorney. But an adjuster choosing the attorney, I think, does not warrant or represent or guarantee any particular final favorable outcome. Now, there are also perils with using in-house counsel. If these allegations are lodged by a policyholder post-trial and you've used in-house counsel, then it can be, it can be an issue. It doesn't necessarily mean it's automatically bad faith, but then there's heightened sensitivity because then there is an expectation that the defense attorney was in fact an employee of the insurance company, perhaps was acting at the direction of the claims department. So if you're using in-house counsel to defend the policyholder, you need to make absolutely sure that you've done due diligence on that attorney and his or her competence, and that you've gotten buy-in from the policyholder as to the use of such in-house counsel. The other takeaway here is that you really need to be attuned to rebut any insured reservations about the caliber or competence of defense counsel, whether that comes before trial or during trial. Now, there's not a whole lot you can do during trial, but if you start hearing either from the policyholder or the policyholder's separate counsel or broker static and noise and concern and reservation about the job the attorney is doing, that should raise a flare, a red flag, that you may be being set up for a bad faith case in case the trial goes sour. And again, you need to make sure that you rebut, that you document in the claim file the reasons why you think that counsel is or was a good choice. And it also underscores the importance, before going to trial, you need to make sure you've got the right horse to go into battle with, and that ideally, preferably, the policyholder has bought into this, that you've got good counsel, competent counsel, has been tested at trial, has the bona fides, has the subject matter expertise, and that the vibes are there for presentation skills, likability, all the factors that go into selecting defense counsel, both objective and subjective. And if you hear any static or reservations from the policyholder, you want to listen clearly, you want to consider that, you want to consider whether you do want to involve another counsel or do whatever is necessary to put the policyholder at ease to either address their concerns or in a nice way rebut their concerns, and to make sure that there is claim file documentation of that. Finally, be aware of potential claims from policyholders that you're penny pinching as an adjuster, as an insurance company claims person, handcuffed defense counsel from doing a good job at trying the case, and that's why we lost the case, because you guys were squeezing the budget so tightly. Now, I'm not suggesting that you have to open the checkbook, open the bank vault, and rubber stamp every expenditure. But I am saying that if you go into trial, go in it to win it. There is no second place. There's no silver medal at trial. Go big or go home. And that means you may have got to spend some money. It may mean that if defense counsel wants some demonstrative exhibits to help him or her project the case, authorize them. If the best expert to nuke the plaintiff's case bills at $600 an hour, that's painful, but you may need to do it. If counsel wants to have a second chair there, somebody else from their firm, to be with them to accomplish tasks that free them up to focus on the direct and cross-examination, etc., I would say authorize it. If you lose the case and there's allegations that you cut corners, or even if there's not, if you lose big, no one is going to pat you on the back and congratulate you for conserving expenses. There is no second place in trial. Go big or go home. Invest the necessary means, financially and otherwise, to position yourself, to position the policyholder to win the case. You follow these tips, there's no magic bullet or guarantee that will insulate you from bad faith claims after the trial. But these are some bad faith pitfalls to be aware of and to avoid. Well, that's the message today from the Claims Coach. I hope that you have found these tips or will find these tips useful. If you want more information on me and my services and consulting and claims services, please visit me at claimscoach.com on the web. Thanks a lot and have a great day.